Specific Relief Act 1963. No appeal over review. Subsection 3. No appeal like from a decision in a suit under section 6, nor any review. Nor any review is maintainable. Nor any review is maintainable, where where a suit upon title is wrongly treated as a suit under section 6 in appeal lie the proper procedure for the appellant. The proper procedure for the appellant court in such a case is to be remind the suit for refresh disposal. Repress suit for refresh disposal in a suit decide under section 6. Revision can be preferred on various ground. If the error is palpable, and the remedy is clear, the High Court can interfere in its revisional jurisdiction. Revisional jurisdiction revisional jurisdiction, but could not interfere on point of law, especially when it is rise for the first time in revision in the absence of juridical error. In the absence of juridical error, juris jurisdictional error, the finding of the lower court cannot be disturbance by the high court. Where in interim order was passed in a suit under section 6 of the Specific Relief Act, it was held that the grant of such in order was not applicable under order 43 rule 1 CPC application of limitation act, section 14 of the limitation act 1963. सेक्शन 14 ऑफ द लिमिटेशन एक्ट 1963 appeal to apply to proceeding dispossession one of the effort could be that time taken in prosecuting proceeding under right jurisdiction would be excluded. Jurisdiction would be excluded. 6-month limitation not applicable to proceeding under CRPC. 6-month limitation not applicable to proceeding under CRPC. The finding that the appellant could have come within 6 months from the date of dispossession was held to be not tenable, as the Specific Relief Act has no application to proceeding under section 145 clause 6 of the Criminal Procedure Code. 145 clause 6 of the Criminal Procedure Code counterclaim and court fees. The defendant was unlawfully disposed and wanted enforcement of this statutory right under section 6 of the regaining possession, a counterclaim was filed against it. The counterclaim being in the nature of a plant in a suit. The court said he did not require to be valid under section 6 clause V 6 clause 5 of the Bombay Court Fees Act. कोर्ट फीस एक्ट हो गया, कोर्ट फीस एक्ट, कोर्ट फीस एक्ट हो गया, कोर्ट फीस एक्ट यानी संतोख सिंह वर्सेस महंत इकबुल सिंह। रिकवरी ऑफ पोजेशन ऑफ मूवेबल प्रॉपर्टी सेक्शन 7 से 8, सेक्शन 7 से 8 रिकवरी ऑफ द पोजेशन ऑफ मूवेबल प्रॉपर्टी सेक्शन 7 से 8 सेक्शन 7 and 8 of the specific relief act 1963 provide method for recovery of possession of some specific movable property. Some specific movable property section 7 recovery of specific movable property. Recovery of specific movable property, a person entitled to the possession of specific movable property may recover it in the manner provided by the Code of Civil Procedure. Code of Civil Procedure 1908 5 of 1908. Explain 1. A trustee may sue under this section for the possession of movable property to the beneficial interest in which the person for whom he is trustee is entitled. Explain number 2. A special or temporary right to the present possession of a movable property is sufficient to support a suit under this section. यानी कि रिकवरी ऑफ द स्पेसिफिक मूवेबल प्रॉपर्टी सेक्शन 7 रिकवरी ऑफ द स्पेसिफिक मूवेबल प्रॉपर्टी मेन इंग्रेडिएंट यानी कि सामग्री मेन सामग्री यानी इंग्रेडिएंट by section 7 it is provided that a person entitled to possession of the specific movable property may recover the same in the manner prescribed by Code of Civil Procedure. The main ingredient of this section are: number 1, the plaintiff must be entitled to the possession. The plaintiff must be entitled to the possession. A person may be entitled to possession neither by ownership or has provided by explain number 2 to section 7 by writ writ of a special or temporary right. Writ of a special or temporary right. It is not necessary, however, that the plaintiff could have been previously in possession or that the court should have been removed from this possession. A special or temporary right may rise by neither. 31 Punjab Urban Planning and Development Authority versus Shiv Saraswati Iron and Steel Re-rolling Mills 1998. The plaintiff has to prove this on case. He cannot think of exceeding because of the weakness of the defendant case. This section corresponding to section 10 of the erstwhile Specific Relief Act 1877. That section carried the following illustration. thus carrying the flowing illustration हो गया, that carrying the flowing illustration. The act of the owner of the goods, the act of the owner of the good यानी कि bailment, plan, pawn, extra. In this case the belly or Pelvanix belly or not by the act of the owner of good, not by act of the owner of goods. Example, finder of lost goods. In this, not by act of the owner of goods, find it lost goods. In this case, the finder of lost goods has a special right to possession except against the true owner. Explanation 1. Make it clear that a trustee is the person entitled to the immediate possession of a true immediate possession of the trust property. Hence, if trust property is taken away by someone, he can recover the same. He can recover the same. He can recover the same. Suit for title. Suit for title. The substantive prayer. The substantive prayer in the paint was for a declaration that the plaintiff were fully entitled to the bonds and certain relief which were founded upon this declaration. A suit for such a declaration would certainly be a title suit so far as the suit bound were concerned. On dismissal for the suit, the appeal against it was brought on the footing that the plaintiff had fully title proved it title to the suit bond, and that the special court had enormous held against the plaintiff. Held against the plaintiff, the court said that looking at the suit from any point of view, it would not be held that the suit was a mere declaratory declaratory suit. It had to be regarded as a suit title. Limitation. Article 91 clause B. Article 91 clause B of the Limitation Act 1963 prescribe a period of the 3 year limitation for the suit. Limitation for the suit computable from the date when the property is wrongfully taken or injured injured, or when the detainer possession become unlawful. Limitation. Article 91 B. Article 91 clause B of the Limitation Act 1963 prescribe a period of the 3 year limitation for the suit computable from the date when the property is wrongfully taken or injured, or when the detainer possession become unlawful. Limitation. Article 19(1) clause B of the Limitation Act 1963 prescribe a period of the 3 year limitation for the suit computable from the date when the property is wrongfully taken or injured, when or the detained possession become unlawful.